Hi there, welcome to Help Solve the Case. I'm Christine Burke. If you don't know me, I'm a retired detective and sergeant, forensic genetic genealogist, and lover of everything court related and the legal system. Today, we are going through a document in the Tyler Robinson, Charlie Kirk trial process. If you joined us or if you reviewed the videos that we have a series from the preliminary hearing, which has been continued to September 1st, and we're waiting for that. Nice enough, I was looking for this document that they referenced. The state and the defense were asked to prepare a brief in between the process. And if you don't follow Adam at The Real One on YouTube, he gets a really deep dive into the Charlie Kirk case. He follows my channel and knew I was looking for this document. And so he was nice enough to find it and share it with me. Let's talk about what's here. Thank you, Adam at The Real One. And if you don't follow his channel, he's got a lot of nice members and everything, listeners, and they've just been really super sweet and really helpful as me here, follow a lot of cases. I really appreciate that. You can get a lot of information. He's usually on live. If you like more of the live format, he's usually on a couple times during the week and on the weekend. So you could go and check that out. I will do my best to remember to put it in the description. Here we have the 4th Judicial District Court for Utah County, the state versus Tyler James Robinson. And this is from the state. They're deputy Utah County attorneys. And they're talking about a memorandum in support of the preliminary hearing bindover. And this was really weird because typically you have the hearing and you don't have two parts of the hearing. You can have multiple days of the hearing, but you don't have it going part here and then part months later. That was very interesting to me. And they're going to get into it here. It says, after taking evidence at the 5-day preliminary hearing, July 6th through 10th, which we got a lot of good information. If you're following this case or not following this case, and now you want to follow this case, go check out the videos because I break down a lot of good information with the witnesses, my take on the witnesses. If you're not familiar with my channel, I've worked in all areas of the system, the criminal justice system, and I try to give a perspective from the state, from the defense, from the judge, and even us as we watch it, which would resemble potential typical jurors. Go check those out. There was a lot of comments, a lot of great information, a lot of things. And I will throw in the caveat here, I do not typically go in depth to the entire case. So yes, there are things that I don't know about, things that I don't talk about, but we do talk about the court process. You may want to talk about that and what the attorneys did in the preliminary hearing. I think we got a lot of information. We got some good lawyering and a wealth of information. The things that we find out in all of these different cases apply to other cases. In fact, I just sent the DNA information about the testing, the Thermo Fisher software alleged issue, even though they published a correction sheet, a patch sheet, or whatever you want to call it. I sent that to a client because their results, their pending results could have been, who knows, affected by that. That's a potential constitutional, exculpatory, who knows what issue. And that's why all of this is important, because we can take stuff from here to there and do that. All right. After taking evidence at the preliminary hearing, they were asked to brief the matter. This is likely as straightforward a bind-over decision. And what they're talking about bind-over means binding Tyler Robinson over for trial. The purpose of the preliminary hearing, if they have them, some states, like Arizona, where I am, they like to go right to indictment. They like to go right to the grand jury, don't have a lot of preliminary hearings, and because there's different determinations. The grand jury is different than an officer's finding of probable cause or a judge's finding of probable cause. The indictment is the indictment. So all these different court processes. What the state is saying here, he's starting out right out of the gate saying this is likely as straightforward a bindover decision as this court will ever see. He's basically saying, look, Your Honor, this is the most, and I don't want to put words in his mouth, but look, this is as most airtight thing as you ever see. Now, just to reference, in the preliminary hearing, it's probable cause. It's not beyond a reasonable doubt. It's not, got different thresholds for bindover. After admitting to several friends, this is the state writing this, including his roommate and romantic partner, that he assassinated Charlie Kirk at Utah Valley University on September 10th, 2025, in front of approximately 3,000 eyewitnesses. Are they eyewitnesses when they didn't actually see him? They eyewitnessed the event, but they didn't eyewitness him actually doing it. Do you think that's important? We raise all these questions here, the semantics and the verbiage. Defendant surrendered to law enforcement for that crime. These admissions, along with others, establish probable cause to support most of the elements of the charges. Whoa. Did something happen that you only have to support most of them and you don't have to support all of them that you arrested the poor guy or girl on? Let's keep going. DNA, let me make sure that I'm reading this right. These admissions, along with others, establish probable cause to support most of the elements of the charges. Maybe he's saying that the admissions, along with other admissions, establish probable cause for most of the charges, meaning now he's going to talk about what supports the rest of them. Let's keep going. DNA testing, surveillance video, and eyewitness testimony buttress those elements. Oh, there we go. Elements, and demonstrate probable cause to support the remaining elements. Hopefully, he's going to lay out element by element how he thinks what is buttressing and supporting what, because he has to meet them. And the judge has to understand that he, meaning the state, meets all of them. The court should bind defendant over for trial on all counts. Facts. On September 10, 2025, Charlie Kirk and his organization, Turning Point USA, were holding an event at Utah Valley University in Orem, Utah. Day 1 at 36.6 to 37.3, 65.4-19. Maybe that's an audio record or that's some type of a Bates number. Maybe that's from the FTR hearing, the for the record court hearing. I don't know if they use that type of software, but that's a brand. Several thousand people attended and filled the amphitheater located near the center of campus and west of the Losee Building. And they've got those parts there. States Exhibits 1, 2, 6, 7, 8. After the event began, Mr. Kirk seated himself under a canopy tent positioned on the west side of the amphitheater below the Hall of Flags. I guess that's the transcript, day 1. And States Exhibits 1, 2, 6, 7, 8. At approximately, that's where they're saying that they prove that or establish that fact that they're asserting here. You can, if you want, I don't know if we'll have time, but you can go and verify that and see if you feel, or we could ask our buddy, our AI assistant, to buttress that and see if we think that happened. Let me know if you want to see that. At approximately 12:23:28, an attendee standing directly in front of Mr. Kirk was questioning him when a gunshot rang out and a bullet struck the left side of Mr. Kirk's neck, killing him. The bullet's trajectory was front to back, slightly left to right, and downward. That's what they're saying. Left to right, looking at him, or from him facing him. The medical examiner concluded the manner of death, quote, to be homicide, end quote. States Exhibit 11 at 1. A forensic examination, I'm not going to read all those numbers. A forensic examination conducted by the ATF revealed that the bullet, I'm picturing we had our person on the stand, right? Our lady from the ATF, revealed that the bullet that killed Mr. Kirk was a .30 caliber class round. It created a, quote, complex entrance gunshot wound, end quote, and fragmented in Mr. Kirk's neck. The bullet, or at least parts of it, quote, sequentially perforated the anterior left side of Mr. Kirk's neck, strap muscles of the left side of the neck, and the left common carotid and left internal and external jugular veins. I'm not sure who's saying this part. I don't think the ATF lady is saying that. Who's saying this? The bullet also, quote, obliterated the left side of the C2 through 7 vertebrae. I'm going to have to go this way then. I don't know, don't call me crazy. I haven't looked at all that stuff. Just reading the court documents and watching the people on the stand. The left side of the C2 through 7 vertebrae and transected the cervical spinal cord case. Parts of it had to be going this way. The medical examiner observed, quote, that, quote, a significant portion of Mr. Kirk's cervical spinal cord was traumatically absent. Mr. Kirk suffered other severe injuries, including, quote, bilateral, apical, and posterior intercostal hemorrhages, pulmonary, apical hemorrhages, hematomas, and multiple disruptions of the thyroid, cricoid, and tracheal cartilages, end quote. The medical examiner also observed hemorrhaging around Mr. Kirk's heart, hemopericardium, both of his lungs, left and right hemothorax, and in the subarachnoid space around, quote, the cerebral vermis and the parietal regions, end quote, of Mr. Kirk's brain. When the bullet struck Mr. Kirk, Officer Christopher Bagley of the UVU police was stationed on the south end of the walkway roof of the Hall of Flags above Mr. Kirk's canopy. That's the first person that I think we heard from, right? The one whose camera didn't work or ran out. Here we go. Based on his experience with firearms, Bagley believed that the bullet came from a rifle fired from a position east of Mr. Kirk's canopy. Recognizing that, one, the Losee Building was east of the amphitheater, and two, someone on the roof of that building would have a direct line of sight to where Mr. Kirk had been seated, Officer Bagley quickly made his way to that roof. Now, just a question here, and I'm just throwing this out here because we look at all sides. How quickly is quickly? Because did we not hear testimony that he went over to the tent and then he was around the amphitheater grass where he saw the holster and he was talking to, didn't he say it was the chief? And then some other unknown officer came up to him and then he went to the roof. For those of you that have listened to the audio or the CAD or any of that, what is that time frame? I haven't heard it. Would you classify that as quickly? And the reason I'm asking that is because verbiage matters, and I don't know if there are fact pattern challenges two statements made in briefs in the preliminary hearing. For instance, things told to the grand jury, things in search warrants can be sometimes challenged. I'm going to leave that there because that quickly, I don't know how I was not from watching the preliminary hearing. I did not myself, my personal opinion, get a feeling of quickly, but I haven't seen the CAD. I don't know the timestamps or any of that. I don't know when the body cam was on or off. So I don't know that, but that word jumps out to me and makes me go in my head. There, he observed a screwdriver about 10 or 15 feet from the guardrail. He also observed disturbances in the gravel at the southwest edge of the roof that were consistent with a, quote, sniper pad, end quote. I thought it was a perch. Weren't they calling it a perch, the sniper perch? I didn't hear a sniper pad, but I could be incorrect. I'm not in the sniping, so I don't know what you call it. I heard a perch. Could be wrong. Meaning a place where a person was, quote, laying in a prone position, end quote, with a, quote, line of sight to where Mr. Kirk had been seated. Officer Bagley reviewed surveillance video of the Losee Building rooftop. That video shows a male running towards the southwest edge of the roof and then dropping down, crawling, and getting into a prone position at that edge of the roof. The video further shows that at approximately 12:28 p.m., the moment of the gunshot, that individual quickly stood up, ran northeast across the roof, carrying a long, skinny black object, and eventually dropped himself down from the northeast side of the roof to the ground. Now, did y'all see a long, skinny black object in that video? Because the video that I remember seeing and photos and whatever, I couldn't see nothing. I know we were precluded from seeing some stuff, hearing some stuff. So I don't know. This is for you guys to do your thing and come back and report to me. Whatever. The hate, the more information, whatever. I'm just trying to support or invalidate the document because the defense is going to respond to this potentially. I don't know. Maybe they're going to do their separate. We don't know. That individual crossed Campus Drive and entered a wooded area on the north side of Campus Drive. In that wooded area, police later recovered a rifle wrapped in a black towel. The rifle was an operable Mauser Model 98 30-06 Springfield caliber rifle. A telescopic sight was mounted on the rifle. Investigators reviewed hundreds of hours of UVU surveillance video to track forwards and backwards the person that was seen on the Losee Building roof at the time of the shooting. Now, we only saw a very short portion of this, and in fact, was it Detective Hull that said, somebody asked him, I think the defense asked him, somebody said, this is only a portion of it. So we only saw in the hearing a portion of it. After defendant turned himself in, investigators also reviewed the footage searching for someone matching defendant's description and driving his car. Those efforts revealed that a vehicle registered to defendant arrived on campus the morning of the shooting. The surveillance video also shows an individual believed to be the defendant walking around the UVU campus that morning, going to the railing on the roof of the Losee Building, and then leaving campus. Investigators ultimately determined that defendant visited UVU campus at least 4 times on September 10th through 11th, 2025, twice before the shooting, a third time just before noon on the 10th, and a fourth time in the early hours of September 11th. That says 2026. That's inaccurate, right? It's a boo-boo, because we ain't there yet. The surveillance video shows that when defendant returned to campus just before noon on the 10th, he was wearing different clothing, but his shoes were the same. Defendant was also walking with a limp. Defendant's roommate and romantic partner, Lance Twiggs, confirmed that still images taken from that portion of the surveillance video and that show front views of the individual's face, quote, definitely, end quote, did, quote, look like, says defendant, end quote. Was that verbatim? Was that verbatim? We'd have to go back and look at that. I felt that there was some distancing there. Qualification. We'll say qualification on the answer. I'm not sure verbatim. I didn't look at that before I'm reading this to you. Given their extensive review of the surveillance footage, I don't know how long did we ever hear that there was an extensive review. Investigators concluded that defendant was the individual who was walking with a limp up to the stairs that accessed the Losee Building roof shortly before noon, who was on the rooftop at the time of the shooting, and who dropped off that rooftop and made his way to the wooded area where the rifle was found. Now, there's been comments and people are asking about how the police don't have to refer to him as alleged and things like that. Here's the paragraph that says here that they have concluded. It's their assertion that their identification was one and the same. Now, I don't know how that's going to be challenged or whatever, the identification. Did we have photo lineups, show ups? I don't know what they're going to use in there. But that's how it went from we've got somebody on the roof to this is the person on the roof. That's how law enforcement is saying this is that person. At approximately 12:36 a.m. on September 11th, defendant returned to the intersection of Campus Drive and 800 South on the UVU campus. He attempted to turn south on Campus Drive, but was turned away by an officer stationed at the intersection. Campus Drive leads to the wooded area where the rifle was found in the bushes. Guys, my eyes are itching and watering. It's my favorite word. DNA testing of the screwdriver recovered from the Losee Building roof and the towel wrapped around the rifle provided, quote, very strong support, end quote, for including defendant as having contributed to the DNA samples recovered from those items. Now, we will put the caveat here. Just because DNA is present doesn't mean the person did something. And this is what the witness testified. This is what the defense is pulling out. This is what, for those of you that watch the channel, I gave you a Thermo Fisher video link talking about this thing that there is a new movement. When this DNA first came out, everybody's like, the DNA's there, gotta be a done it. But now there's huge strides in just because it's there, because we're learning more about DNA, the potential for transfer of DNA, all this stuff, that It doesn't mean, and I'm not saying one way or another in this case, I'm just saying that there exists this, I don't even know if it's a paradigm or whatever we want to call it. Just because it's there doesn't mean the person did the action. The activity is what they're calling it. And especially when there are items that are routinely in the accused person's proximity or purview. All right. We have to be cognizant of that. I want to say paradigm, but I don't think that's the right word. DNA testing on the recovered rifle's trigger guard, grips, protected underside of the receiver, and other parts, as well as the fire cartridge casing in the rifle, supported including defendant as having contributed to the DNA samples recovered from those items and areas. And if you have not watched my video, thank you everybody. It was watched so many times. I tried to go through and really talk about these numbers. The defense went really through this, which they were arguing didn't belong at a preliminary hearing. But here's my alliteration. We really got a primer on these calculations, these numbers, and the contributors, and how to get the number. You have to assume or guess at the number of contributors, how the human process comes into this process. Not only do we have presence versus activity, we've got how do we get to, when we talked about this, if you haven't, go watch the video about who is going to be a known contributor, like the roommate, versus the suspect. Very interesting, very interesting. On the evening of September 11th, I'll try to remember to put that in the description. I'm not so good yet of putting all the things in the timeline and everything. I'm working on it. I'm trying to learn little by little. Thank you for bearing with me. On the evening of September 11th, 2025, defendant surrendered himself to law enforcement in connection with Mr. Kirk's assassination. Defendant also admitted to Mr. Twiggs and other friends that he had shot Mr. Kirk. The state charged defendant with count 1, aggravated murder, capital felony in violation of Utah Code 76-5-202, count 2, felony discharge of a firearm causing serious bodily injury, a first-degree felony in violation of Utah Code, blah, blah. Counts 3 and 4, obstruction of justice. I'm not going to read all that. Counts 5 and 6, and count 7, the child. And we have the targeting enhancement. What does that say? Information. I guess they got that from the information. The state also notified defendant that counts 1 and 2 were subject to sentencing enhancements for committing a violent offense in the presence of a child and victim targeting. We've got the 2 enhancements. Argument. As a magistrate, I'm talking to the judge, the court has but one duty left: to determine whether the evidence admitted at the preliminary hearing supports, quote, probable cause to believe that the crimes charged, end quote, in the information have, quote, been committed and that the defendant has committed them, end quote. Do the elements of the crime exist? That's every element. And there's a video going through the information where I elaborate on that if you want to look for that one. It will be in the pending trial playlist. We've got to meet every one of those elements. That's what they're saying here, that the probable cause supports all of the elements. It means that did everything that they say happened criminally. And then is the person charged the person that did those things? Is there probable cause to believe both? It's like a 2-part test. Utah Rules of Criminal Procedure is limited to determining whether probable cause exists. The state says this isn't a closed case. The state presented more than enough evidence to support a probable cause finding on all 7 charges. At this stage, the state must demonstrate only probable cause, not beyond a reasonable doubt, a reasonable belief that a crime was committed and that defendant committed it. In determining whether the state has surmounted this, quote, low bar, the court must view all the evidence and all reasonable inferences therefrom in the light most favorable to the state. And I'm going to interrupt myself and digress here a little bit, because this phrase, and this has nothing to do with this gentleman, the state, or whatever, but this phrase really irritates me here, because they're talking about, look, all we have to do is this low bar, probable cause, and it needs to go to trial. But how many times have we heard from victims, especially in the federal system, where the federal prosecutors, because police officers in the federal system can't just do things on their own. They have to have approval from mommy and daddy to do a lot of things, whereas local law enforcement officers are trusted to do their job without oversight. But it seems to me, and this is my personal opinion and experience, that in the federal law enforcement system, and even sometimes in the local cases, we hear prosecutors coming out and saying, nope, we're not going to do it because it's not a winnable case. But here's the bar: probable cause. And if someone is telling you, I can't prove this case beyond a reasonable doubt right now, I think that's the cart before the horse. I'm just throwing that out there because it's irritating to me. In this case, we hear, look, we only need this little bit. This guy is willing to go for it and work for it. And again, meaning no disrespect to this guy, it has nothing to do with this case. I'm talking about cases in general, because there's so many cases that nothing's been done, or the case has been dropped or whatever. And this is this much. When the other one says, no, I can't prove it beyond a reasonable doubt. No. Lots of problems in the system. Thank you for letting me get that out. The purpose of a preliminary hearing is not to determine the guilt or innocence of an accused. Rather, its purpose is limited to, quote, ferreting out, ... groundless and improvident prosecutions. Use alliteration. Improvident prosecutions. Is that unprovable? Is that a different word for unprovable? Haven't heard that before. Thereby sparing defendants in those circumstances, quote, from the substantial degradation and expense incident to a modern criminal trial, end quote. They quote State v. Anderson. The preliminary hearing is a constitutional safeguard against, quote, unwarranted, end quote, prosecutions where, quote, it manifestly appears either that no such crime was committed, remember we have to meet the two-prong elements, or that the suspicion entertained of the prisoner, the whodunit, is wholly groundless. Under the Utah Constitution, the line separating a valid prosecution from a groundless prosecution is probable cause. It doesn't say beyond a reasonable doubt, does it? Now, truthfully, we don't want everybody just taken to court because people have a hunch or a bias or anything like that. But what I'm saying is we also have a group of people, we need the safeguards. We have a group of people that can't even get anything done in their case because it's not provable. It's not a gold star win. And the gold star win is not at the front of the case. It's at the end of the case. That's the prosecution's job, is to build the case and put on the case, to put on the Netflix show and win the Emmy or whatever it is, right? It's not at the beginning of the case. The crime happened. And if the crime happened, justice needs to be served. It has to go through the system. That's just my opinion. All right. Utah Constitution, Article 1 and 12. They quote that. If the evidence supports, quote, probable cause to believe that the crime charged has been committed and that the defendant has committed it to prong test, the magistrate must order that the defendant be bound over for trial. This is a, quote, low bar, saying it again. It does not require proof beyond a reasonable doubt as required for a criminal conviction, and it, quote, is lower even than a preponderance of the evidence standard applicable to civil cases, end quote, which is true. Thus, a probable cause showing does, quote, not even require the prosecution to eliminate alternate inferences thought in favor of the defense, end quote. You understand what that's saying? They just got to pick one theory and run with it. That's a very important statement. All right. How can I explain this? I'm trying to think of a good analogy. It's like they don't have to have a full cup. And I'm using a cup as an example because they quoted the preponderance of the evidence. In civil cases, they always characterize it as 51%. So that would be just over half a cup. But in a preliminary hearing, probable cause is 1/3 of a cup. And what they're saying is they don't have to provide, even if there could be other items in the cup or other possibilities filling up the cup, they only have to claim their 1/3 of a cup. If there are, and they use the word alternative inferences, which God forbid, I'm just throwing this out there, alternative suspects, alternative theories, alternative stuff that favor the defense, it says, thus a probable cause showing does, quote, not even require the prosecution to eliminate alternative inferences, quote, thought in favor of the defense. Now, I've spoken to you guys about how I work my cases as a cop, and I do stuff. I get into cold cases and investigative stuff and forensic genetic genealogy. And me personally, I don't want stuff hanging out there. I don't want alternative theories, unknown DNA, all kinds of crazy stuff coming back to bite me. I project myself into the shoes of the defense. What is it going to be challenged on? What else could they say? Could there be somebody else? What is the DNA saying? Like Koberger case. Who's all this other DNA that we didn't know about? We just had, who else is? We were talking about another case, and I was talking to a client with another case. And it's a situation where, kind of not like this case, but in the fact that these are materials and things routinely shared in a household. Like in this case, where the roommate's DNA, they called it a known contributor. The defendant in the case, my case that I'm talking about, would be a known contributor also, but they chose to make that person the suspect for whatever reason, the DNA or other things, right? So like in this case, they're saying, we've got these admissions and we've got this video where we can clearly identify Robinson, and we got his DNA. But this sentence here, according to the state of Utah, this prosecutor says, and I'm not the attorney, he's quoting Lopez here, a probable cause showing does not require the prosecution to eliminate alternative inferences. They don't have to weed it out. They only need 1/3 a cup. And it's not 1/3 a cup, but I want to give you a visual, because 51% is typically the visual, the analogy for a civil case. They only need a third a cup or a quarter a cup, an eighth a cup. They don't have to fill the rest of the cup. An overflowing cup is the jury's decision, if we use that analogy. He's saying it's a very low amount. We're talking about, hold on a minute. Here's my very dirty measuring cup that I use for watering my plants. Hopefully you can see the water in there. That's a quarter cup. That's not even, and the water's cloudy because it's been outside, but that's a quarter cup. That's not even an eighth of a cup. Look how much the rest of it in a criminal case doesn't have to be there. That's a lot. When you say to me, but they didn't talk about this, they didn't show this, they didn't do this, they didn't check that, and the tires are different, and the front end is, I get it. But he's saying, according to the law, they don't have to do that. They don't have to eliminate every possibility. They don't, according to what he says. They don't have to. Now, at trial, the prosecution has to overflow this cup. Hopefully you can still see it. They had to overflow this cup. They have to get from here all the way up here and over it, beyond a reasonable doubt. If we're using this as our analogy. Now think about that. I'm mentioning here that I, as a cop, I want to eliminate all that and make sure that that there is no other alternative, because when the prosecution gets the case, theoretically, oh wait, but you guys be able to see this. I'm holding it in front of my face so you can see it. The police have done all their work most of the time, because when we talk about UCR and uniform clearance, an arrest is a clearance. It's, here you go. I'm done. All right. Police department's done. They made their arrest. Where do cases get problematic? Because the prosecutor only has this much to work with, potentially, if the police, and I don't want to say it's not a good case, because they only need probable cause. But if they didn't build up a good case and eliminate all those possibilities, then the prosecution have to come up with that, all of this overflowing cup, after the process, which could be DNA testing, witness interviews, and all that stuff. That is a very hard hurdle, many times, in my opinion, for the prosecution. Looking, and on the defense side, looking for other exculpatory information, the rest of that cup. And that's why they can't get to beyond a reasonable doubt, because they didn't fill their cup up. So if we look at the defense side, they only need a little bit of doubt. So their job is easier, right? Because they don't have to fill this cup up. They just need an eighth of a cup or a 15th of a cup or 16th of a cup or whatever, however that goes, right? They just need a little bit. But the prosecution has to fill this puppy up, and it has to overflow. When they already have to meet speedy trial, if the defendant doesn't waive speedy trial, and they got to get all this DNA testing, experts lined up, and all this stuff, it's better to build a good case, speaking from the cop perspective, on the front end. So when it's good to go, it's good to go. For instance, in the Carmelo Anthony case, in a homicide, and this is my opinion, I'm not talking about guilt or innocence or anything. I'm talking about process. When the officer arrested him immediately on the scene and he was claiming self-defense, the clock starts ticking, as they say. And I said, wow, you have a homicide. And he immediately arrests the guy when the guy is claiming self-defense. Wouldn't it be better to take an interview, get the prosecutor involved, and fill the cup up before the clock started ticking? I don't know if that helps, but trying to illustrate the difference, because everybody, I can't say everybody, folks are misunderstanding this probable cause, and I know folks are outraged on both sides, but there's a process to it, and good work on the front end leads to easier work on the back end. Hopefully that illustration helps. All that is required is, quote, sufficient evidence to support a reasonable belief, end quote, that the defendant committed the charged crimes. And they quote State v. Labrum. A criminal prosecution is groundless only if the evidence presented at the preliminary hearing fails to establish probable cause, i.e., if the evidence is, quote, wholly lacking and incapable, end quote, of supporting, quote, a reasonable belief that the defendant committed the charged crime, end quote. They quote State versus Virgin, and stated another way, the magistrate, I don't want to go there yet. When we're talking about this reasonable belief that the defendant committed the charged crime, we talk about this reasonable person standard. And right now, we have people in the public, you've talked to them, no matter which side you're on, that are like, yep, he did it, and no, he didn't. And right now, all you need is reasonable people that say, yep, he did it. That's it. The cop said, yep, he did it. The prosecution said, yep, he did it. And so they're hoping that the judge is going to say, yeah, it's reasonable. It's not the whole enchilada. It's just a bite, but we only need a bite. And then the process before trial, and the defense challenges and the constitutional challenges and all that is to drain this cup. Drain this cup of every bit of anything so that it can't overflow with proof beyond a reasonable doubt. Hopefully that's a good analogy. Stated another way, the magistrate may, quote, decline bindover only where the facts presented by the prosecution provide no more than a basis for speculation, end quote. And I will let you determine your own word definition for speculation, how that might apply to the case. And they quote Lopez. And they might determine speculation in Lopez if you want to go read Lopez. We're only on page 8 of 28, so I'm not going to do that now. Importantly, the magistrate at a preliminary hearing, quote, quotes are weird, must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, end quote. It's tilted towards the prosecution. The magistrate has only a limited role in judging the credibility of the evidence at a preliminary hearing. A magistrate may disregard or discount the prosecution's evidence only if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the charged offense on that evidence, end quote. I don't even know how to explain that statement in an analogy. Otherwise, I'm thinking about, do I put an elephant in here? I don't know. I don't know how. I don't know even how to, an alien on the roof. I don't even know how to give you a visual on what so contradictory, inconsistent, or unbelievable. I don't even know how to explain that. But think about something like that. Like there was an elephant on the roof, and they were saying that it was Tyler Robinson. And forget about AI for right now, but that's not clearly not a person. Like an elephant is not a person, right? An alien, a ghost, an apparition. I don't even know how to explain that sentence. Otherwise, a magistrate, quote, may not accept the defendant's version of the facts over the legitimate inferences that can be drawn from the prosecution's evidence, end quote. Even though the defendant is innocent till proven guilty, here they're saying the magistrate, quote, may not accept the defendant's version of the facts over the legitimate inferences that can be drawn from the prosecution's evidence, end quote. It's like, nope, nope. You have no access to the cup at this point. You only have access to the cup at trial. It's what I say it is. Here it is. And you don't get access to the cup until the trial. They quote People v. Hall and Virgin holding that magistrate, quote, may not prefer one piece of credible evidence over a conflicting piece of credible evidence in making the bindover determination, end quote. That's a confusing sentence. I'm not even going to try to interpret that. The state introduced ample evidence to demonstrate probable cause to believe that defendant committed all 7 crimes charged in the information. In this case, the state presented, quote, more than enough evidence so as to sail safely, they love this alliteration, over the bindover standard, end quote, on all 7 charged offenses. They're saying the evidence establishes probable cause that the defendant committed count 1. They're going to elaborate it first. We don't have to do that. To establish that the defendant committed aggravated murder, the state must prove that defendant, Tyler, intentionally or knowingly caused the death under circumstances in which he created a great risk of death to another individual other than Charlie Kirk and defendant. Those people standing next to him, the bullet could have fallen short. What do you think? The evidence readily establishes probable cause to support each element. This is the state saying this. Element 3, death. They're going to take it element by element. And when we talk about a crime, these are the elements. Each piece, each element has to be satisfied. They're saying element 3, death. Mr. Kirk was killed. Element 1, identity. The evidence further demonstrates a reasonable, so you just see a reasonable person, just say, looks like him. And who do we have that said that? His roommate. And they say boyfriend, lover, whatever, girlfriend, whatever romantic partner, let's call it that. That said, yeah, looks like him. The defendant was the shooter. Defendant repeatedly admitted that he shot Mr. Kirk using his grandfather's rifle. Now we got all these statements. Defendant also surrendered to law enforcement in connection with the shooting. These are the parts that the state is saying that it's the defendant. DNA testing supports the conclusion that defendant contributed to the DNA samples recovered from the fire cartridge, the trigger and other parts of the rifle, the towel, and the screwdriver recovered from the rooftop. Let's just take, even if we take, and we're at probable cause, we're not trying it. Even if we take the DNA out because it could have come from the house, they're saying we got the ID from the roommate. We've got admissions. We're going to keep going because I know you guys are, we have this activity versus presence issue with the DNA, and I agree with that. That's hard to prove. Defendant's car was at the UVU campus, blah, 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 blah. And not only did defendant admit that he was the one depicted in the published screen captures from the UVU surveillance footage, defendant's roommate and romantic partner confirmed that the individual in those screen captures showing the individual's full face, quote, definitely, end quote, and y'all can check that, looked like the defendant. Remember, he was on the Zoom. There's the identity part they're saying. Element 2, and they're spelling it out here. They're like, Your Honor, there's no reason. We are going to hand it to you morsel by morsel. Mental state. That's the intent. The state's evidence also demonstrates a reasonable belief that the defendant intentionally or knowingly caused Mr. Kirk's death. A person acts intentionally, quote, with respect to a result of his conduct when it is his conscious objective or desire to cause the result, end quote. A person acts knowingly, quote, with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result, end quote. A criminal defendant's mental state is, quote, rarely susceptible of direct proof, end quote. But they're saying mental state, right? Hard to interpret that. But they're saying this case is exceptional because, as shown above, defendant repeatedly admitted that he intended to cause Mr. Kirk's death by shooting him with a high-powered rifle. He wrote it to Mr. Triggs that he, quote, had the opportunity to take out Charlie Kirk, and he took it, end quote. He also texted Mr. Triggs that he had been planning the killing for, quote, a bit over a week, end quote, and that he killed Mr. Kirk because defendant had, quote, had enough of his hatred, end quote. Defendant also engraved the bullets that he loaded into his .30-06 caliber rifle. He also took some target practice before the shooting and engraved one cartridge found in his home with the words, quote, test shot, end quote. The circumstances of the shooting itself, when properly viewed in light most favorable to the state, further demonstrate that the defendant intended to cause Mr. Kirk's death by shooting him. Defendant first surveilled the campus. Then he changed his clothes and returned to campus with the rifle. Defendant used a screwdriver to assemble the rifle on the roof. With that rifle loaded, With that rifle loaded with 4 engraved cartridges, defendant then crawled to his sniper perch, now it's a perch, on the edge of the roof, took aim at Mr. Kirk, and pulled the trigger. The evidence overwhelmingly demonstrates that defendant acted with the required mental state. Element 4. Aggravating circumstance, knowingly creating a great risk of death to another. The state's evidence, properly viewed, also demonstrates a reasonable belief that defendant knowingly created a great risk of death to another. In Mr. Kirk, defendant fired a high-powered rifle towards a crowd of thousands. Defendant created a great risk of death to everyone who was in his line of fire or who was near Mr. Kirk when defendant pulled the trigger. They're going to explain that a little bit. The Utah Supreme Court analyzed the, quote, great risk of death, end quote, aggravator in State v. Sosa Hurtado. Reviewing its prior case law, the court recognized that this aggravating circumstance, quote, is met where another person is placed, quote, within the zone of danger created by the conduct that caused the victim's death, end quote. They're saying being in that line of sight puts you in the zone of danger. Some factors to consider in identifying this zone include the temporal ... relationship between any actions the defendant may have taken towards the third party and the acts constituting the murder, the spatial relationship ... between the third party, the murder victim, and the defendant at the time of the acts, and whether and to what extent the third party was actually threatened by the assailant, either by direct threats or indirect means, such as the risk of stray or ricocheting bullets. And that's what they're going to say here. Applying these factors here, the state's evidence establishes a reasonable belief that the defendant knowingly put several people within the zone danger he created when he shot Mr. Kirk. Most significantly, everyone in the defendant's line of fire was within that zone of danger. The person questioning Mr. Kirk when the defendant pulled the trigger was within the defendant's line of fire. The questioner was just a few feet in front of Mr. Kirk and directly between the sniper perch on the Losee Building and the roof and Mr. Kirk. Thus, the, quote, spatial relationship between the questioner and Mr. Kirk put the questioner within the zone of danger. So not only are they saying the flight path, but they're saying this one person, all those people that were on the ground. Not only that, the flight path, if the bullet dropped down or whatever, but this person that was right as the, quote, spatial relationship between the questioner and Mr. Kirk put him within the zone of danger. The questioner's proximity and placement relative to Mr. Kirk also created an, quote, indirect threat to the questioner given, quote, the risk of stray or ricocheting bullets, end quote, or he could be a bad shot. The same factors apply to the several others who were directly behind the questioner and thus also within the defendant's line of fire. The evidence also demonstrates that defendant was not certain to hit only his target, Mr. Kirk. Defendant loaded his rifle with 4 cartridges, creating a reasonable inference that he anticipated that his first shot might miss. Moreover, evidence of defendant's target practice before the shooting shows that he did not always hit the bullseye. Wow. Throwing that in there. Indeed, some of his shots completely missed the paper target. Did you see what they're doing here? They went and gathered. They're not just saying, look, there was a crowd of 3,000 people here within that pie or whatever you want to call it, this way, that way. They're saying, look, there was one right in front of him. And then there were several people. And there could have been a stray bullet. But even further, he had 4 bullets. And then he won a great shot. They're not given much wiggle room with this extra part here that it could have harmed somebody else. And even if defendant had previously calibrated his rifle and scope, they're adding more, but wait, there's more. He had disassembled the rifle to transport it to the roof undetected and then reassembled it on the rooftop using the screwdriver he left there. One reasonable inference, using the word reasonable, from these facts is that the reassembled rifle would not be as accurate as previously as when it was sighted in while in one piece. They're putting that together there. That's some strong, I gotta give them props for that. A defendant who shoots another knowingly creates a great risk of death to anyone within his line of fire. See Commonwealth v. Watson. The Pennsylvania Supreme Court had no trouble finding that the defendant in Watson, quote, knowingly created a grave risk of death to another person in addition to the victim of the offense, end quote, when, while shooting his ex-girlfriend, her child was in a closet and, quote, the closet and the child were in the line of fire, end quote. Also, Sylvia B. State, holding that the defendant, quote, knowingly created a great risk of death, end quote, to people who were in his, quote, line of fire, end quote, and they go to these cases. The evidence demonstrates that defendant here knowingly created a great risk of death to the questioner and all the others who were within his line of fire. The distance from defendant's sniper perch to the tent where Mr. Kirk was sitting was approximately 410 feet with a 68-foot vertical drop. 410 feet is less than the 415-foot distance from the home plate to the center field at Coors Field in Denver, and approximately 137 yards is just longer than an American football field, including 2 end zones. From defendant's perch, he could see the questioner and those directly behind him, and presumably even hear the questioner because the speakers had been set up to amplify the discussion. Defendant could certainly see these individuals through his rifle's scope. I guess they're trying to point out in a normal sports event that people in certain places can see other people, that he knew that he could hurt other people. Defendant could certainly see these individuals through his rifle's scope. Defendant was therefore, quote, aware of the existing circumstances, end quote, including all the people in his line of fire when he fired the fatal shot. I'm going to stop here and I'm going to break this into two. We are halfway through. We have another part to go. Very interesting. This is very good examples of building a case, making sure you have all the elements and how the state says that they intend to prove it. And we'll go through this with the document once we get the defense's filing. Thank you for being here. Look for part two. I'm going to go ahead and record part two. And you can go back in all these parts where they're checking here at the trial transcript and stuff. I have commentary and stuff from each day of the hearing, but you can go and search it and look at it on YouTube or whatever. If you want me to, we can try to line this up play by play or whatever. But this is the state's argument as it comes in. We've got our second part of this hearing on September 1st. We hope to be live for that. And we are waiting for the defense's documents. Stay tuned. Look for the second part of this, and we will be doing the defense's document. Thank you for being here, and we will see you on the next one.